This is Paul Turner, immigration barrister at Imperium Chambers. Thank you for tuning in. Please subscribe to my channel. Some good news for once. The Upper Tribunal has opened the door to more people who have overstayed for longer periods of time in the United Kingdom being entitled to qualify for indefinite leave to remain under the 10-year rule. If you are thinking or want to make an application for indefinite leave to remain, please get in touch with me as the law in this area is complex and is apparently changing all the time, though in this case it's changing in applicant's favour, which is a pleasant change. What is the cause of this good news? Well, the Upper Tribunal has recently confirmed that you can still get indefinite leave to remain on the long residence route when you have had gaps in your leave that have previously been disregarded. These gaps can be quite considerable, as I will explain later, and will not mean you are refused indefinite leave to remain. This turned on the case of Asif, which has recently come out and clarifies this area after some confusing decisions from the Court of Appeal. Mr. Asif qualified for indefinite leave to remain even though there was a gap of 507 days in his leave, which is way beyond 28 days or 14 days, etc. It's long been the case where you have a short delay in making an application for further leave after your visa has expired, and then it is granted that short period will be disregarded and you will be granted leave to remain. But when it comes to getting indefinite leave to remain under the 10-year route, you still need to have continuous lawful residence. So do those small gaps which were overlooked at the time count towards your continuous residence? On some previous cases, the answer would be no. However, and that's what the Home Office argued in the case of Asif. They tried to argue that those gaps could not count towards your continuous lawful residence in relation to an ILR application. Now, the background to this is fairly brief. Mr. Asif was in the UK and made an application to extend his leave to remain in February 2013, which was refused. There was then a further challenge to this, and then he made another application within 28 days, but was not granted leave until some 507 days later. He appealed in time, but withdrew his appeal in July 2014 and made the subsequent application, which was subsequently approved. His application was granted following a judicial review, but it was 507 days after his last visa had expired. It was this gap of 507 days that he said counted towards his lawful residence. The Home Office tried to argue that it didn't count, relying on a case from Ahmed from 2019, and you'll recall there are two Ahmeds. They said that although the period of overstaying had been looked at the time, it was not the same as him being in the UK lawfully for that period. But, and this is the crucial factor, the Upper Tribunal disagreed. They looked at the case of Hock from the Court of Appeal and held that his overstaying by a considerable period of time could count towards his continuous lawful residence, as the application itself was made within 28 days of his last leave expiring. What this means is essentially periods that you have stayed in the UK beyond your visa, but where you have had a valid application or appeal outstanding, can be converted into lawful leave, or as it were, or continuous lawful residence for the purposes of an ILR application. This is good news for people that have had only short gaps in their leave following the expiry of previous visas and now want to extend them to apply for ILR. But the case of Asif shows that even gaps of 507 days can still be converted into lawful residence and treated as continuous lawful residence for the purposes of paragraph 276 of the immigration rules. The key thing is that as long as you've made your applications or submitted your application shortly after your previous leave's expiry, you should be able to argue that any gaps in your leave can be converted and count towards your continuous lawful residence. So this is a positive decision. It's a bit complicated. The law in this area has been changing. There's been conflicting Court of Appeal decisions, but this seems to be the latest word on it. So if you've had previous leaves and you've got, and then the secretary, and then you make an application out of time, and it takes the Secretary of State a huge amount of time to consider it, and then you get leave, whilst you may not have had leave for that period of time, if the Home Office then grants you leave, it can be disregarded. So this is a very positive decision and could change the landscape for a huge number of people who have previously had gaps in their leave. as I say, it is complex, it is complicated, and if you want any advice or guidance on this, please do not hesitate to contact me, and I'll do my level best to help you. Once again, thank you for watching. It's been a pleasure to talk about something positive for a change. This is Paul Turner, the Immigration Barrister to Imperium Chambers.